Welcome to the Two Heads podcast with me, Lorna Hackett, and Michael Mansfield QC. In this episode, we're talking about crime and punishment, the proportionality or otherwise of punishments and perceptions of the criminal justice system, as well as redemption and restorative justice. We hope you enjoy the show.
Crime and punishment.
Crime and punishment, exactly.
The punishment, really, because I think you have much more extensive experience than I do with
punishment.
Cases arising out of prison situations.
Well, if we're talking about crime and punishment, you are the crime and I am the punishment.
Okay. You're being punished for my crime. Okay, off you go.
But no, I've spent a lot of my career representing prisoners in custodial settings. Variety of settings, all the way from the Special Secure Unit in Belmarsh all the way down to open prison. And I'm really interested in the effectiveness of punishment and imprisonment and the parole board's test for release, which is whether or not it's necessary for the protection of the public that the offender remains in custody, and whether that's the appropriate threshold, whether it puts the onus too much on the prisoner or whether it's the onus on the Secretary of State, because in some cases it's not always clear. And also what happens to people when they go to prison. Because it's not just about the prisoner, it's about what happens to their families and their friends and the void that's left in a community, not just for the prisoner, but of course the victims too. But is it right that we segregate people from society? And is that actually punishment? Or is it punishment enough? And do we have the right model? And I think that one of the other things that I'm really interested in, I've campaigned for many years, is for people who are serving imprisonment for public protection, which is a sentence which was brought in under the Labour government, April 2005, which meant that it was much easier for judges. In fact, it was mandatory for judges to give indeterminate sentences for relatively minor crimes, and indeterminate meaning that the prisoner could not be released until they had satisfactorily reduced their risk, such as to be able to be released into the community. Now, those were abolished under the Legal Aid Sentencing and Punishment of Offenders Act, along with EPPs, Extended Sentences of Public Protection. But there are still hundreds of people in prison who are serving IPP sentences who have never been released. And I represent one who wants me to talk about him, and he's in prison for attempted robbery of a cigarette committed in 2005. He got a 2.5-year tariff, thereabouts, and he's into his 17th year of imprisonment. He's lost his wife, his children haven't spoken to him for years, and he is hanging on by a thread. And if you talk to any prisoner who's serving IPP, what they say is the worst part of their imprisonment is not knowing if or when they will ever be released. Now, in terms of never knowing, or that complete uncertainty, everybody should have some kind of target, exactly. But what has happened to IPP prisoners is that they have become like whole life tariff prisoners. So there are very few whole life tariff prisoners in this country. I think around about 50, something like that. So they're never going to be released. Whereas these people have really committed really minor offences in comparison, but have no basis to have any hope.
I mean, I'm really completely overwhelmed by the example you've given, because, forget the cigarette for a moment,
Mm-hmm.
You can't go around locking people up because you've got some test that they're a threat to the public.
Mm-hmm.
I don't understand this at all. I mean, you've got to have a bearing on the offence. The sentence has got to relate to the offence as well as the offender. So the offence is obviously out of the picture here. He stole a cigarette. I mean, what is the criteria?
Well, it wasn't even he didn't even steal a cigarette. It was attempted street robbery.
Attempted street robbery. So what's the threshold for establishing that you're no longer a threat? What is it they need?
Well, he has to show that it's no longer necessary for the protection of the public that he remains in custody. Now, the vast majority of people who are so significantly post-tariff, who are IPP prisoners, who have never been released before, either have just have given up and can't abide by the rules, or they have significant mental health issues or drug addiction problems, or personality disorder issues.
All of those could have been produced by the length of the sentence you're serving.
Correct. And that, to me, is such an injustice. And I know that there's consultations going on as to what they should do, because the legislation is already there, they need to enact it. But really, not many people, it's a sort of dinner party conversation that I have with people. I talk to people about imprisonment for public protection. People say, what? That can't be happening. How on earth are these people still in prison? And they are. And it's disgraceful.
Is there any movement towards?
Yes, they're trying, but they've been trying for a long time. And I started a campaign in 2010 to try to get the IPP abolished, and it eventually was abolished. I'm not saying that it was down to me, but the fact that we're still having this conversation 10 years later is the concern.
Yeah, okay. I just want to broaden it out a bit. I mean, that's a very important issue, but an even bigger one is, which crops up from time to time, is obviously, in principle, how do we deal with people convicted of extremely violent crime? Now, that obviously can be sexual crimes, terrorist crimes, God knows what. Everybody can think of the heinous crimes that occur. Leaving out of a picture at the moment people who are wrongly convicted, but people who are convicted, and let us suppose it's a true bill and they are guilty for the moment. So how do you see the way forward in dealing with that? I mean, is it right to lock them up for very long periods of time because of the offence they've committed and the risk they may recommit, or for a retributive aspect? I mean, what is it we're looking for here?
Well, the parole board's test is about risk to the public and whether or not it is appropriate for somebody to be released on licence. But if we go back to the prison rules, the purpose of imprisonment is to encourage people to lead a good and useful life. And of course, if you're just locking somebody up for 23 hours a day, how is that encouraging them to lead a good and useful life? Surely that's creating a situation in which they might be released eventually feeling totally separate from the world and not encouraged to do anything pro-social. And it would encourage you simply to deceive the parole board, say what you have to say in order to be, you would hope that wouldn't necessarily happen, because the parole board does do a very thorough job in conducting risk assessments relating to people's suitability for release. But it can't be right that you remove, and this, sadly, I've seen it over the years since the budget cuts and austerity, a lot of the workshops, a lot of the work that people were able to do in prison, the courses, the rehabilitative schemes have been eroded and have been cut. And so, especially over the last 2 years, people spend 22, 23 hours a day just locked in their cells, either on their own or with one other person. That is not, and I appreciate, we are in the middle of a global pandemic, but I struggle to see how that's going to improve significantly unless there's massive investment in what people can do. Because I've spent a lot of time in prison talking to prisoners, and so many of that, there are some really there's some really interesting people in prison who are, I would say, capable of a lot when they finally get out. But they have to be encouraged, they have to be supported. That's not to say that they shouldn't be punished for what they've done, that there should be, obviously they should be rehabilitated. But to write people off because of their convictions is, in my view, completely the wrong way about it.
I mean, I've obviously been concerned from the court point of view, because I've done 2 major trials, at least 3, concerned with prison riots at Risley and at Strangeways. So I'm very familiar with a remand system in which there's no real regime and it's 23 hours a day. And of course, high security prisons where there's, again, deprivation on a major scale. So, but what I'm asking myself is, are there humane alternatives for people against whom there are these severe allegations of violence? For example, I'm just using that.
When you say humane alternatives,
well, ones that don't involve the kind of deprivation and almost, well, this is going back, I'm afraid, Lord Longford and some of his work as well. I mean, are you locking people up, throwing away the key and saying, that's it? Is that an acceptable approach? If it's not, and you're looking, as you've been talking about, the possible re-entry of people and the possible, I'm not remotely religious, but using the word salvation of souls and all the rest of it, that it's possible that, and I think everybody's a possible candidate for some form of redemption. Again, another religious term, but what I'm meaning is people who accept a sense of responsibility and are given a chance, even though the person who they may have killed or mutilated has never had that second chance. And I recognize the parents, the loved ones and families of the person who's being mutilated are not going to enjoy this sort of discussion. But, you know, we have to contemplate whether we want a system that just locks people up and that's it, or whether you give them, as one contemplates, that's what all the conventions on human rights and all the rest of it are about, is to ensure, even in a sense, what we do to the prison population is a reflection of the nature of the society in which we live.
I'd just like to take a moment now to mention our amazing sponsors, Clio. As I'm the head of legal practice at a law firm, I'm always looking for ways to become more efficient, to save time on administrative tasks and to keep track of client contact and matter management. And I have to say, Clio allows me to do all of this and so much more. At Hackett & Dabbs, we've been using Clio for about the last 18 months and it has been absolutely brilliant. Importantly, it allows me to free up my valuable time to devote more to my clients and to the matters that I am so passionate about, like social justice. Clio offers really great customer service, flexible contracts and a free trial so you can try out their software before you buy. They're also really nice people who are totally committed to achieving access to justice for all in society, including the most vulnerable. In short, I would recommend Clio to any lawyer or law firm. To see for yourself why I'm so pleased with them, visit www.clio.com/UK/2heads. That's www.clio.com/UK/2heads. And now, back to the show. Well, I think over time people can change, and there are countless men in prison in particular who have committed violent offences in, say, for example, their early 20s, who are now in their mid-40s and who are rehabilitated. And who are we to stand in the way if they genuinely want to spend the rest of their lives actually making a difference to society in a positive way, knowing full well what they've done, knowing that they can't bring that life back, but being fully committed to actually making a difference for the public good subsequently?
What about war criminals? I mean, it takes a lot of thoughts, but don't worry. I mean, I find that difficult too,
yes.
Because usually, not always, I've been involved in cases in The Hague, the International Criminal Court, where you're dealing with the possibility of genocide, you're dealing with the possibility of mass slaughter. And these are really crimes you don't want to contemplate if you can help it, because they're so bad. So, and obviously, if you go back to the Second World War and the Holocaust and all the rest of it, those are equally bad. And of course, that was the whole objective of the Convention on Human Rights at the end of the Second World War and the establishment of international conventions and courts. And of course, in 1998, the International Criminal Court was set up in The Hague. So when you're dealing with them, it's a separate category. People seem to be saying, and of course this leads in the background to sort of capital punishment, is, you know, they've got to be locked up and that's it. I mean, do you have thoughts
Well,
about?
I think it depends on the severity of the crime, certainly. But I mean, those are very serious crimes.
They're nearly always in the top category.
Yeah, absolutely.
Because there's nearly always more than one dead. They're nearly always a sort of systemic situation. They're born out of hugely bitter conflict, tribal conflict in a sense that it involves a national identity. And of course, it's a bit easier to describe it in terms of the Nazi regime. But there have been other regimes since then that have done some, the Viet Cong and so have done some pretty dreadful things, very dreadful things. And, yes, so that leads into, I suppose, do you dispose, which is a word I don't like, but that's the word that's often used, is the disposal for those cases where you should contemplate, as they did at Nuremberg, death sentences, capital punishment?
Well, I think there are ways in which you can adequately protect the public from harm, which do not involve taking another life.
What are they?
Well, the whole life tariffs would be one way.
Okay, I'm sorry, just going to sort of put our own principles on the line a bit here. So if you're going to, you say, yes, well, it's better not to take their lives away. The argument goes that if you lock somebody up in the conditions in which Nazi war criminals were kept in Berlin and elsewhere, which is pretty well in isolation, pretty well, without any benefits of any kind. And people say, yeah, too right, should happen. Well, then that's equivalent to a living death. Do you see where I'm going here?
I do, but I think if you start, if you introduce capital punishment, then where does there's always the risk that you extend it into other areas and other crimes. And then it becomes a question of, well, what level of crime warrants capital punishment? And then you start thinking, well, hang on a minute, given that there are miscarriages of justice, how can we possibly have a situation in which somebody could have been...
I mean, obviously, the miscarriage of justice history that I've got, I'm certainly not in... It's the major argument I would use domestically against any form of capital punishment, leaving aside the moral issues. The legal issues, I think, are no-brainers. There's no answer to it, because the risks of a human criminal justice system making a mistake are extremely high. Even juries, which we may come to, make mistakes. And of course, the classics, I can line them all up: Guildford 4, Birmingham 6, Tottenham 3, Cardiff 3. They've all got numbers on them. Fortunately, a number of them, because capital punishment had been abolished, they weren't executed, but a number of others were. One of them, a man from South Wales called Matin, who was quite wrongly convicted, and it was all discovered too late. He'd been executed, and it was found later that the police had their eye on somebody completely different, and he doesn't match the description. So that's an example of a miscarriage and then an execution that follows. So I quite agree that almost, yes, I would say there is no domestic crime, even if there's more than one person killed. So I suppose the obvious one would be Myra Hindley, which comes to mind, but there are lots of others. Even if you've got serial killers, that you would want to employ the death penalty because of the risks that you run domestically in your domestic system. It can be very wrong. And I'm not yet convinced that the international system of justice, which is very important and has not been used as sufficiently as it should. And why? Because some of the big states, like the United States of America, have refused to join up to the Treaty of Rome, which set this international court up in the first place. So, and why? Because they don't want to end up in the dock, no doubt. So it's about time this was pointed out yet again that they don't do it. And if there's any chance of trying to get states into the International Criminal Court, where these very serious heinous crimes are tried, of course, the Security Council one route in, and the Security Council is unbelievably divided along the lines we've already discussed. So it's a serious problem. However, coming back to the question of sentence, when you're dealing with, well, let's take the major one where, people found culpable for genocide. And unfortunately, genocide is not infrequent. trials for genocide are infrequent because you've got to get the evidence, you've got to get witnesses, you've got people come out to the woodwork, all sorts of things. But if there are people who are convicted of that, then there could be mistakes, of course, even at that level. Although I'm not sure I'm aware of any cases at the Hague where people have said, mistakes have been made in the trial. Milosevic, for example, is one obvious example. So I think then you're led back into the moral argument. Are you saying there are no circumstances where the state should be entitled to take a life for a life, which is the sort of semi-religious spiritual argument? I mean, do you think there are no cases where that should happen? Or
yeah, I think there are no cases where that should happen. I think that families of victims, for example, may well say, my son or daughter was taken, or my spouse, and therefore the only thing that will suffice is the perpetrator's life to be taken too. But again, yes, losing your liberty to that extent, given how the prison system works, is significant punishment.
So I'm just thinking back to talks we've had already about reconciliation. I mean, maybe there should be. This is. I'm thinking of it as I speak, so I may get this terribly wrong, but perhaps we should be contemplating the possibility of an international court that finds the facts, and we've got that, or the possibility of it. It's not as effective as it should be, but that's not the fault of the people who work in the court itself. That is the fault of international organizations. That we could have a court, a tribunal, that has parallel, if you like, avenues. One avenue is the current one, which is proof, conviction, sentence. But maybe you have one running alongside, which is reconciliation. Mm-hmm. Now, the advantage of that might be that you might get more cooperation, because the big difficulty with the ICC at the International Court is that, to begin with, and still is, some nations, particularly in Africa, will not, because they've got their own organization as well, but they're saying, the International Court is concentrating on the smaller powers in order to convict people and so on, and it's biased. So we don't want to have anything to do with it. Whereas if you had a reconciliation avenue and pathway, which was more fairly, as it were, attributed, so it applied to a much broader range of states, you might get people being prepared to participate in that, because they would have, if they confessed and admitted, and there was a process of reconciliation. So in all those areas, those theatres of conflict we've already touched on, there might be a better chance of getting a form of justice that actually everybody wants, because you want justice for the past, and you want justice for the future. So it's the Martin Luther King thing about truth and justice. Well, truth, he was talking about you can't have peace without justice, and I think you can't have justice without truth. So these three things go together. So if you're dealing with an international context, you have to have the three components: truth, peace, justice. Sometimes they won't happen if any one of them's missing. Sorry, I'm just...
No, that makes sense. And I think if looking at the sort of criminal process, you have an event, a process, and then punishment. But of course, in what you're talking about in terms of reconciliation, then actually it's much more of a sort of advocate for peace, as opposed to, because then people feel that there is an end to something. A criminal trial and a sentence of imprisonment does not end future criminal trials. It's not a learning process necessarily for the parties involved. It's bitter, it's awful, it's traumatic, it's life-changing, and the ripple effect is huge. Whereas if this type of process is much more about improvement on a societal basis.
You used a particular word there, learning. And I think you were involved, and would like to be involved, if it were to be properly resurrected is learning together. I'd like to know a bit. I've not been involved in it, so I'd like to know a bit more.
Yes, well, learning together is started by Cambridge University, and it's in other universities as well. And it's the basis on which serving prisoners learn alongside, so sitting next to each other in prison alongside students of a university. And I've taught some lessons in prison for students of Learning Together. And I've seen firsthand how transformative that can be to the outcomes of the prisoners involved, and also to the students. So some prisoners would never have met anyone that's been to university before, for example, could never imagine in a million years that they might have the capacity to be able to learn alongside people who they view as intellectually superior. Or maybe they've never even thought about higher education, but showing them that it's possible and that it's something that they can aspire to, and that they'll learn things from their fellow students. Similarly, the students have probably never even thought about going into prison or being in prison. But there's a mutual sort of trust and respect between students, prisoner students and non-prisoner students, that develop really interesting collaborative projects in terms of the work that they did. I've looked at some of the work they've done. I've marked some of the work. I've given feedback and that kind of thing. And it's a really powerful process, I think, for both sets of students. So,
does it carry on once they're released? Is there an aftercare thing now?
Well, there's certainly in terms of Learning Together, there's a sort of community of students, ex-students and ex-prisoners, all of whom keep in contact with each other. And a lot of people's lives have been changed for the better by the experiences they've had. That's not to say, of course, that what happened at Fishmongers Hall was not appalling, and the effects felt very widely.
Just elaborate
afterwards.
a little bit
Yes.
more about Fishmongers Hall.
So Fishmongers Hall was the 5-year celebration of Learning Together, which was held in November, 29th of November 2019, at which a variety of people from the criminal justice system, ex-prisoners and students at Cambridge University.
And this was in London?
At Fishmongers Hall on London Bridge, yes, or just off London Bridge. And one of the students, or the alumni of Learning Together, went along and killed 2 people involved in Learning Together. One was Saskia Jones and the other one was Jack Merritt.
So what's the ripple effect of this now?
It's huge.
Just
it's absolutely huge. I don't know a single person who I know from Learning Together, from Cambridge University, from prison as well, whose lives haven't been completely changed as a result of what happened on the 29th of November 2019. Totally changed. And sadly, Learning Together is no longer in Cambridge University. They recently made that announcement. And I think it's an absolute shame. It is a really sad...
I mean, what's the university's worry?
You'd have to ask the university, I think.
Well, are they worried about image?
I would have thought that's part of it. But yeah, I mean...
they can't be regarded as some form of collusive terrorist organisation. That would be ridiculous.
No, I don't think that's it. But they've cut Learning Together loose, and I think it's a real shame, because while I understand, I suppose, why they might have done it, it removes and somehow shrinks the importance to so many hundreds of people, and that is a real shame. And that is, I think, something that I know that a letter was written in response to what happened in terms of Cambridge University stopping Learning Together, but a lot of people were very upset by it.
Because I mean, it's a shocking event, but I think one shocking event can't be turned into complete disaster for everybody when there's an organisation striving. And obviously, from what you say, I didn't know a lot about it before you started talking about it. From what you say, is really having a great deal of success. So actually, it's generally protecting society in a quite different way by incorporating people and embracing, and I think, it's back to the aspect of compassion and so on. All of that seems to be thrown to the wind.
Well, at its heart was the understanding that education can be the key that unlocks life for people. And I excuse the pun, but in reality, if you are not going to educate prisoners, and that really, that should be done in prison anyway, people should have access to a means by which to better themselves on an educational level. There used to be funding, but a lot of it has been cut. Yes, there's still the Prisoners Education Trust, but a lot of people are no longer eligible for funding that they otherwise would have been. And so...
Sorry, do you mean individual prisoners are not eligible?
Yeah.
I see. And they're not eligible because of the offence they've committed, or...?
No, just because funding was cut and rules have changed and that kind of thing. But Learning Together offered access to levels of education that were otherwise completely inaccessible to people. Previously, people used to be able to do open university courses and full degrees, and that has been significantly limited. But again, it was something useful to do with your time rather than being given a colouring in book because you're behind your door 23 hours a day. That's not a good use of anyone's time. That is just to relieve boredom.
It's probably a step beyond relieving boredom. That's bad enough. But it's about what you want your prison system to be and how you value human life or not. And you don't, it seems to me anyway, you don't value human life by reducing its existence in this way. And whatever the person has done, I'm leaving out the international court for the moment, but I do worry about cuts of this kind are in the long term, counterproductive.
Well, if you're going to encourage people to lead a good and useful life, let's assume that they're going to be released at some future point, then how are you doing that? By not providing them with anything to do. And that's the problem, because nobody wants to be useless. Nobody wants not to have a purpose. And whether that is from a prison or not, you don't lose your humanity because you're in prison. You're still a person. Those rules still apply to you. And so, of course, people want to do something, to be able to make a difference.
I mean, you touched on it a bit, but I think the public also are interested in the role of the parole board and whether they get it wrong or they get it right, and the criteria they use. Because you hear terrible tabloid stories about people being released when the parole board either didn't investigate it enough or used the wrong criteria and allowed somebody out which they knew full well was a risk, and that sort of thing. I don't say I believe all this. But...
Well, there's the parole board's been quite significantly overhauled in recent years and made more transparent. So there are summaries of things of parole board decisions, for example, now that are available. And there's also there's a process of reconsideration. So if the prisoner or the Secretary of State thinks that a decision is wrong, then either party can appeal it.
How easy is it for a prisoner to get somebody like yourself to represent them and get it funded? Or
yeah, well, there is legal aid for parole board hearings, but it is very limited. Yeah.
Well, just to explain that, it's very limited so that are there things you can't do?
Well, it's on a fixed fee basis. And so, but the amount of work that goes in versus what comes out of it is very modest fees.
So does this mean there aren't too many lawyers who want to do it?
That it's a niche area. Can I put it that way?
That's a very polite thing to say, yeah. Well, so that's sort of an end. It's not a product, but it's an end. The product makes it look as though we're dealing with some kind of commercial venture. But there's a process of trial that comes before.
1 minute.
Yes, well, this is the next section,
Yes,
which is the trial.
the trial.
The trial. So
That's what we're going to talk about in
Yes.
the next episode.